Alright, chapter 209, subpart C, part 209, subpart C, with compliance orders, 209, 201, the compliance orders generally. Subpart screw out the rules of proceeding, the leading with the issue, with the compliance with the orders pursuant to the Federal Railroad Safety Law, with the Title 49, U.S. Supreme Code 5121A, and the 2, or 2011 1B, with the FRA may commence with the proceeding of the subpart FRA for the reason believing that the person is engaged in the conduct of pattern with the conducting involved with more and more violation of the Federal Railroad Safety Law, with the regulation and order of the issue and with the law of the FRA exercise of the Environment Enforcement Authority. 209, 203, the notice of the investigation. After the beginning of the compliance order proceeding of the preserve of the notice of the investigation, the name of the respondent notice of the investigation contained with the statement of the legal authority for the proceeding, the statement of the factual allegation upon which the remedial action being sought, the statement of the remedial action being sought in the form of the preservative purpose compliance, proposed compliance. The FRA may amend the notice of the investigation at any time prior to the entry of the final compliance order. If the amendment includes any new material, allegation, facts, seek the new additional remedial action, respondent given an opportunity to respond. 230, 209, 205, reply within 30 days of the service of the notice of investigation and respond to the file made with reply with the FRA of the Chief Counsel extended the time of the filing with good cause. The reply must be written with the signed with the person filing state with respect to the effect each of factual allegation, whether admitted or not, even though formally denied the factual allegation set forth in the notice of the investigation is considered to be admitted for the purpose of proceeding unless they oppose the affidavit as an individual having the personal knowledge of the magic change the death is defective on its face together with supporting explanation as well why it's believed and defective otherwise actively put to the issue of the submission of relevant evidence. The reply must be set forth in an affirmative defense with including the statement of the form, nature of the proof of which the defense is to be established. It is necessary to respond to the amendment of the notice of the investigation. Respondent may be the amendment of the reply with concern with the substance of the matters contained in the amendment of the notice within time before the issuance in order of 209 and 211. If the respondent elects not to contest one or more of the factual allegations, he or she should state with the part of the election does not contest the factual allegation that admission of the allegations solely for the purpose of issuing the compliance with the order of the election of the Constitution, the waiver of the hearing of that allegation that does not in itself constitute the waiver of the right to be heard the other than the issue of the in connection with the statement of the election not to contest the factual allegation. The respondent may propose the appropriate order of the issuance of administrative purpose negotiation and consent order. For the respondent fail with the reply with the period provided with the constitute with the waiver of his or her right with the appear with the constitute obligation authorized administrative with. Without further notice, respond with the final facts of the alleged with the notice of the proposed violation issue with the appropriate other directing of compliance. 209, 207, the consent order. At the time before the issuance of an order 209 and 211 of the Chief of Counsel, the respondent execute with the agreement to propose the entry of the consent with the order of directing compliance with the administrator may accept the proposed order, signing of the administrator to reject the proposed order, or he or she to direct the proceeding to continue with the agreement to submit with the administrator on the subsection, including proposed compliance with the order distributable with the administrative subject signature of the admission of all the jurisdiction facts and expressly with the further procedural steps of all the right to seek the judicial review, otherwise challenge the contest validity of the order. And acknowledgement that those notice for the investigation may be used to construe the terms of the order. 209, 209 hearing. When the respondent filed with the reply with the contesting of the allegations of the investigation, if the 209, 203 with the FR with the respondent failed to agree with upon acceptable consent with the order of the hearing of the Fisher officer designated with the Chief of Counsel. Chief of Counsel conveying to the presiding officer of the hearing of the proposed compliance, the presiding officer may have the administrator over the affirmative affirmations, issue of subpoenas to provide in the 209, 7 of the adopting proceed with the submission of the evidence, take the cause of the disposition of the take of the rules of the officers, the proof of the proceed with the relevant accident, evidence, 6 examine the witness for the hearing, at the hearing convey, 7 convey the reset, the reconvening, and the rejourning, and otherwise regulate the course of the hearing. Hold conferences and settlement simplification issue the other proper purposes to take any other action authorized consistent with the provisions subpart pertaining to complying with the order of the affirmative law which may expedite hearing aid with the disposition of the issue with the raised therein the Chief of the Counsel their burden provided the facts alleged with the notice for the investigation may offer the subject relevant information may be necessary fully to inform the presiding officer of the matter concerning the respondent may appear to be heard on his or her behalf through the counsel with his or her choice. The respondent with his or her counsel may offer the relevant information including the testimony which he or she believes that should be considered in the defense allegation may be the bearer of the remedial action be sought with the conduct of the such cross-examination may be required in full disclosure of material facts. At the conclusion of the hearing, soon after the hearing officer shall provide the party of the may file with the proposed finding of the conclusion together with the supporting reason therefore. 209-211, the presiding officer's decision. After the consideration, after the presiding officer dismissed the notice of investigation, after the compliance with the order's decision from the presiding officer will include the statement of the findings of the collusion as well as the reason thereafter all the material issue, the fact of the law, the decrease in the compliance order issued under the section with the effect of the 20 days of the service of the respondent unless provided therein. Alright, 209-213, and plea with any part of the aggravated the presiding officer's decision may file with appeal within ensure the appeal must be filed within 20 days after the service of the presiding officer's decision provided the printing of the file determination of the appeal. Administrator may remand the case for the further proceedings before the hearing of the officer. The following appeal does not state with the effectiveness of compliance order of the administrator that expressly so provided in this 209-215 time limitation proceeding issuance of the compliance order under the Federal Safety Act, Railway Safety Act of the 1970 amended shall be completed within 12 months after the issuance of the notice of investigation. Subpart D disqualification procedures.